Thank you, Mr. Chairman. Thank you, General Lynch, for joining us today. The Department of Justice, pursuant to the All Writs Act, recently obtained a court order requiring Apple to engineer software that doesn't currently exist, that would enable the government to bypass security mechanisms built into an iPhone previously used by Saeed Farouk, one of the San Bernardino terrorists. Now, importantly, there were several phones that were used by the two San Bernardino terrorists. All of the other phones were destroyed. All of them were crushed and were inaccessible because they didn't physically exist anymore. This particular phone was a work phone, and some have speculated that perhaps that's why it wasn't destroyed. Perhaps it was being used for work purposes. But regardless, this particular phone, because it wasn't destroyed, is the subject of this effort by the Department of Justice. It resulted in this effort by the Department of Justice to require Apple to engineer software that doesn't currently exist. Now, the All Writs Act, importantly, provides that the Supreme Court and all courts established by acts of Congress may issue all writs necessary or appropriate in the aid of their respective jurisdictions and agreeable to the usages and principles of law. So it's not open-ended. It doesn't require the court, allow the court to demand anything and everything. It still has to be agreeable to the usages and principles of law. Is it nonetheless your position that the All Writs Act permits courts to compel private parties to engineer software to assist law enforcement?
Senator, as has been laid out in the pleadings in the relevant case, it's our position that the All Writs Act, as interpreted by a variety of courts, including the Supreme Court, does require third parties to provide assistance to the government when necessary and when they are capable of doing so to execute lawful court orders. The specifics of that assistance will vary from case to case and will essentially determine, how the third-party person is able to provide the assistance, under what means and measures. So the All Writs Act provides the legal authority for the court to order this third party to provide assistance. The type of assistance will vary from case to case.
But what limiting principles would exist if, in fact, the All Writs Act can be read to authorize a court to develop software that doesn't already exist, to enlist the work effort of a tech company to create something that doesn't yet exist? What limiting principle is there? And I would add, what limiting principle is there in place that wouldn't also allow the government to use the All Writs Act or some other mechanism to require Apple, for instance, to write other software, perhaps software that would unlock a phone's camera, unlock a phone's microphone, unlock a phone's location services system, in order to assist the government there, assuming Apple or whatever other company is at issue doesn't have software that would do that? What limiting principle would stop the government from going into court using the All Writs Act to compel that kind of work product?
I think in every situation you'd have to look at the type of assistance that was needed. In the relevant case here in San Bernardino, the government is not asking Apple to unlock the phone, but to disable a password blocker that would destroy the evidence.
Understood. And Apple is saying that would require the development of new software. They'd have to engineer something that doesn't currently exist.
But that is not Apple unlocking the phone or Apple going into the phone and extracting it, or Apple taking certain steps. And so every case, as we know just from watching jurisprudence, will be developed by the relevant facts. I think in this instance, it's important to note that this is a customer request for a company to provide assistance to a customer. This request first came from the owner of the phone. And so I think that's an issue that's of relevance and importance in this case also. And every case is going to be different. I think what we've tried to do is have a very narrow, very focused inquiry into potential evidence on one device.
It's important to remember that the Supreme Court has stated in Pennsylvania Bureau of Correction versus U.S. Marshal Service, a case decided by the court in 1985, that the All Writs Act is a residual source of authority to issue writs that are not otherwise covered by statute, where a statute specifically addresses the particular issue at hand. It is that authority and not the All Writs Act that is controlling. Now, importantly, there is a law that deals with issues in this area. The law is, of course, called the Communications Assistance for Law Enforcement Act, or CALEA. It explicitly states that, that CALEA, quote, does not authorize any law enforcement agency or officer to require any specific design or equipment, features, or system configurations to be adopted by any manufacturer of telecommunications equipment, close quote. CALEA further states that, quote, a telecommunications carrier shall not be responsible for decrypting or ensuring the government's ability to decrypt any communication encrypted by a subscriber or customer unless the encryption was provided by the carrier and the carrier possesses the information necessary to decrypt the communication, close quote. Does CALEA apply here?
Senator, I think that the relevant laws that we feel are applicable are laid out in the pleadings in the San Bernardino case, and so I would refer you to those briefs rather than have such a limited discussion about one law here.
I understand this is a limited discussion and our time is limited, but it's important nonetheless. And my understanding is that the Department of Justice is taking the position in those pleadings, in those briefs, that CALEA does not apply. And yet that seems odd to me because Apple is, in fact, a manufacturer of telecommunications equipment. And Apple is, in fact, being asked to be responsible for decrypting or ensuring the government's ability to decrypt an item that Apple itself manufactures. I also find it troubling that we've got a situation here in which this administration and many others were calling on Congress for a long time to require by statute that Apple and other similarly situated manufacturers provide a backdoor and a backdoor key that could be used by law enforcement. That effort failed, but that effort contemplated changes to CALEA. Because that effort failed, it's that much more disturbing that because there was not enthusiasm in Congress because there were very legitimate public policy concerns expressed in connection with that idea. Congress declined to adopt such legislation. Now that Congress has declined to adopt such legislation, then and only then, the government goes into court. At about the same time, it decides not to pursue this remedy in Congress and tries to get through the All Writs Act, this 1789 statute that was intended to not apply in circumstances like this, where the area has been addressed by statute, a remedy that it couldn't get through Congress. This is a policy decision. This is not a judicial decision. It should be handled by Congress, not the federal courts. Thank you, Mr. Chairman. I see my time's expired.